Ready, start. The appellant was arraigned as an accused in connection with a first information report within bracket for short comma single inverted comma the FIR single inverted comma close bracket close for the offences punishable under sections 302 comma 201 and 34 of the Indian Penal Code comma 1860 within bracket for short comma single inverted comma the IPC single inverted comma close bracket close full stop. He was not named in the FIR and was formally arraigned as an accused in the third supplementary charge sheet under section 302, 201, 34, 120B IPC read with 25, 27 of the Arms Act. Full stop. The learned additional sessions judge passed an order dated 20th October 2023 discharging the present appellant in connection with all the offences subject to furnishing a personal bond in the sum of rupees 25,000 with one surety of like amount to the satisfaction of the jail superintendent. Full stop. A revision application was filed by the first respondent NCT of Delhi, challenging the order of discharge before the High Court of Delhi. Full stop. A prayer was made in the revision application for stay of the order of discharge. Full stop. By the first impugned order dated 21st October 2023, while issuing a notice in the revision application, the learned single judge of the High Court stayed the discharge order. Full stop. It was an ex parte order of stay, which was extended from time to time. Full stop. An application was filed under section 390, read with section 482 of the CRPC, by the first respondent in the revision application seeking a direction against the appellant to surrender to judicial custody on the ground that the discharge order has already been stayed. Full stop. By the second impugned order dated 4th November 2024, the learned single judge of the High Court held that on account of the stay granted by the High Court, the appellant cannot avail the benefit of the discharge order. Full stop. Therefore, the High Court observed that if the custody of the appellant is not secured, the order of stay granted by the first impugned order will become ineffective. Full stop. Therefore, by the second impugned order, the appellant was directed to surrender before the trial court and was granted liberty to apply for bail thereafter. Full stop. While issuing notice on 11th November 2024, this court stayed the second impugned order. Full stop. However, this court clarified that the High Court was free to proceed with the hearing of the revision application. Full stop. Sri Siddharth Luthra, the learned senior counsel appearing for the appellant, submitted that the High Court ought not to have stayed the order of discharge. Full stop. The consequence of the stay order is that the trial will proceed against the appellant, though he has been discharged. Full stop. He submitted that unless the order of discharge is set aside, the trial cannot proceed. Full stop. He submitted that the appellant has been discharged for the cogent reasons recorded and that the order cannot be nullified by granting a stay. Full stop. He submitted that the grant of stay to the discharge order would virtually amount to allowing the revision application without examining the merits or demerits of the discharge order. Full stop. He submitted that the appellant has complied with the directions issued by the Sessions Court of furnishing bail in accordance with section 437A of the CRPC. Full stop. Therefore, the presence of the appellant is secured, if at all, he is required to face trial. Full stop. Learned Additional Solicitor General appearing for the first respondent, strenuously urged that though a strong prima facie case was made out to proceed on the basis of the charge sheet filed against the appellant, the learned sessions judge has passed an order of discharge. Full stop. He pointed out that it is a very serious case of murder of a former member of the Legislative Council of Jammu and Kashmir and the chairman of Jammu and Kashmir Gurdwara Prabandhak Committee. Full stop. He submitted that apart from the CCTV footage, there is evidence of CDR and eyewitnesses. Full stop. He submitted that the order of discharge is perverse, full stop. He submitted that the learned judge of the High Court had recorded a prima facie finding in the first impugned order that the learned sessions judge had overlooked the material evidence, full stop. Inviting our attention to sections 397 and 401 of the CRPC, the learned ASG submitted that the High Court has the power to stay or suspend the operation of the impugned order, full stop. In fact, as per subsection within bracket 1 of section 401 of the CRPC, the High Court, while dealing with a revision application, is empowered to exercise all the powers of the Court of Appeal under sections 386, 389, 390 and 391 of the CRPC, full stop. Therefore, after admitting the revision application for hearing, the High Court had power under section 390 of the CRPC to direct that the appellant should be committed to prison. Full stop. He urged that considering the prima facie finding recorded in the first impugned order, the High Court had every justification to order the appellant to be taken into custody. Full stop. This is the rationale of section 427. Full stop. As soon as the High Court, on perusing a petition of appeal against an order of acquittal, considers that there is sufficient ground for interfering and issuing process to the respondent, his status as an accused person and the proceedings against him, revive. Full stop.